Any mention?
Yes.
Chief, I beg to mention item number 9.
Yes.
Your Lordship, I prayed for 2 weeks' time, Your Lordship.
You are making a mention on behalf of the
Respondent, Your Lordship.
yes.
For 2 weeks' time.
Your
It's
Lordship,
okay. What is your thing?
I need early disposal. Let it be for this time. Next time, I'll finish.
Okay. You are preparing for all the respondents.
yes, Your Lordship.
The request of the respondent. This is matter after 2 weeks. Okay. Yes, Mr. Mann.
With the Lordship. Lordship, I beg to mention item number 10.
Yes.
Lordship, 2 weeks' time I can leave the granted mandate.
No objections, Madam.
Further basis.
You also have no objection. Okay. This
Obligation.
10 at the request
You're
of the
right.
petitioner after 2 weeks. Yes.
Right. Chief, I beg to mention item number 13 and 14.
Yes.
Yes, the matter may come up after 3 weeks, Lordship.
No objections, Your Lordship.
13, 14, these are connected matter.
Connected matter. Earlier, Your Lordship has fixed WPC 418 for hearing. In the meantime, from the other bench, WPC 417 has been recused. So it has also been tacked up together.
So this is tacked in the means whether this the relief claim for is similar here.
No, not similar, but pleadings are more or less similar. In one, the certificate is involved, and another is past certificate is involved. So if the matter is taken up together, then it will be convenient for the parties as well as for the court also.
13, 14 also. After
3 weeks, Lordship.
3 weeks as request of the petitioner. Yes.
Obliged.
Please, Your Lordship. Your Lordship, I beg to mention item number 11, Your Lordship.
Item number 11.
Yes, Your Lordship. Mr. Pubin is still on sanction leave, Your Lordship, so I can pray for 2 weeks' time, Your Lordship.
That is that land acquisition matter.
Yes, Your Lordship.
It was hard at some length. Mr. Shen.
Mr. Sen is.
He's already informed, Your Lordship.
Lordship, we have no objections, my lord.
When do you want it?
2 weeks, Your Lordship.
Same. 11 also same. As the request of the petitioner. Yes.
Deeply obliged.
Item number 11.
Item.
Item number 11. Sorry, 2. Item number 2. I prayed before after 2 weeks' time. My
Item
lord,
number 2. It's orders. Part 1. Wait. Let the matter be called.
Yes, my lord.
It's not a hearing item. Wait for your time. Yes.
Your Lordship, item number 15. Your Lordship, I pray for 3 weeks' time.
You're appearing for?
Petitioner.
Yes. This is
POXO, for quashing of POXO.
one. What is the thing? That is.
That
What is the
issue
ground
is,
taken?
the issue is that they are in relationship and having one
So the
child
same
also.
thing.
Their
Same
husband,
issues.
Yes, husband and wife.
Okay, this also after 3 weeks as the request of the petitioner. Yes.
Lordship, I
Yes.
beg to mention item number 16, Lordship.
Yes.
I'm praying for 1 week time, Lordship.
Lord, I have no objections. In fact, my lord, the matter is pending before the division bench. Compromise.
This item number 16.
Quashing.
This is also a POXO matter.
Lordship.
Yes, Lordship.
The same issue.
Lordship.
Then what purpose it will serve if it comes up after 1 week?
Yes, Lordship.
What purpose it will serve if it is listed after 1 week?
Lordship, I have no.
Now, if the issue is pending before division bench, are you aware of the fact? You are not aware of the fact.
Lordship. Yes, Lordship.
Yes, Mr. Ranjay, this is pertaining the same thing. Is it?
Lordship, more or less, because like a day of compromise and everything, like when the marriage was registered and all.
The issue is same here.
Lordship.
But then on the day of incident,
She's a minor.
the survivor was minor.
Lordship.
One week, Lordship.
Make it one. Make it one. Yes.
Deeply obliged.
Obliged, sir.
Yes. Perfect.
Daily causeless, item number 1.
May it please your lordship.
Yes.
Lordship, I'm making a plea on behalf of Mr. S.N. Can you grant me some time, my lord? Because I seek consent of the other party to enable us to prepare the matter.
What was the issue here, Mr. Sangresho?
Regarding, my lord, the non-adherence of the Section 15 of the Land Acquisition Act. After issuance of Section 11, preliminary notification, the collector has to give opportunity to the landowners. Here, the opportunity was not given. So that is the main issue here. The last occasion, we are good to some extent, and the chair prayed for some time.
This court has forgotten everything, Mr. Sangresho. There appears to be no. Did you submit any note of your hearing? No, you have not submitted.
Not yet.
Not.
But
Okay. When do you want it?
After 2 weeks, my lord.
You are there also, Mr.
I'm there.
Your Lordship, in this case, they are supposed to submit this name of the parties who got the compensation.
That was also to be submitted. Was it to be furnished?
Well,
The name of the persons who have already got compensation?
no.
Was there as a
No,
requirement?
no. Earlier, my lord, the learned chair pointed out some of the landowner received, so he wants to ascertain, apart from other aspect of the matter. So on that ground, it was adjourned.
How many petitioners are here?
My lord, 90 petitioners are here, and some of the petitioners received, and 3 petitioners withdraw, deleted from the area of the parties. Remaining are still remaining.
Oh, there was an issue of order on Rule 8 also.
Yeah, that one. Lordship allow us to withdraw. We got instructions. They are yet to give an instruction as to whether they will withdraw or not. Because the issue remained the same. ROW. The compensation offered to them is beyond the ROW. So some of them have received. But ROW issue remained the same.
The problem, Mr. Sangresho, we hear a matter for at some length and then
Right.
get adjourned and all, then everything. Yes, when?
After 2 weeks, my lord.
Just say. Mr. Soinja, just Mr. Inja. Non-net counsel, applying for the state face of grant of 2 weeks time. Mr.
Deeply obliged, my
Senior
lord.
counsel for the petitioner has no objection to a allowed list of 2 weeks. Yes,
Right.
deeply obliged.
Item number 2. Item number 4.
Lordship, I pray that this matter may come at the end of the board, Lordship.
Why at the end of the board? It is for service, pending for service.
Lordship,
I am entering appearance for a 4.
Yes. And then what is to be done then?
So we'll let the matter be heard after a week.
It's ready for hearing.
Ready for hearing.
Okay, we'll fix it for hearing then.
Yes.
After end of the board, Lordship.
Why?
Mercy,
Why?
yeah. He is having some.
Why?
It'll be
at the
after
end of
2
the
weeks,
board?
Your Lordship.
Yes. Mr. Hassan has entered appearance on behalf of respondent number 4 today. You will not file any objection.
No, orally.
And submits that no objection is required to be filed in the matter. Mr. Shulai Lanit AG submits the matter is ready for hearing.
Lordship.
In view of the above, this matter for hearing after 2 weeks.
Lordship. Pavla, Your Lordship.
Item number 5.
Your Lordship, the learned DSJ has some submissions to make in this matter. Your Lordship, we may kindly have this matter at the end of the board.
Who is appearing for the petitioner?
Your Lordship, Sylviana.
It is pending for what?
Your Lordship, it's a NDPS matter, Your Lordship. It's with regard to the bail application.
None appears for the petitioners. So and so appears for the respondent. List this matter after 2 weeks.
Much obliged.
Yes.
Supplementary causeless hearing. Item number 1.
Yes. Yes.
Well, she was supposed to get instructions on whether she's going to withdraw the matter or.
Your Lordship, I have taken instructions. We'll proceed ahead with the matter, Your Lordship. Hearing may be done.
So this settlement will not work.
No, Your Lordship.
Yes.
If they are not agreeing for quashing of it, then we'll go for hearing. Merits on merits of the case.
So my learned friend means to say that the settlement has not been arrived at. On the basis of the settlement, the matter can be quashed, my lord. But if I don't understand, both the parties have signed the settlement. Now my learned friend says that we want to go on merits. It's a different issue altogether.
Your Lordship, our instruction is if they are not agreeing that this matter will be quashed as per the settlement.
I agree with that. If that is the case, then my lord, at the end of the day, the only thing I wanted to say is why will the court
that if this matter is quashed on the basis of the settlement?
Your Lordship, if
so, that is what Mr. Gautam also seems to be agreeing. Then, what is the problem then?
on the basis of the settlement, the matter may be quashed. Well, my only anxiety was because as per the agreement, it was decided that the matters would be withdrawn. Now, unless this 482 was withdrawn, I could not withdraw the FIR. But if the matter is quashed, then the question of withdrawing the FIR will not come.
We can withdraw the FIR. One FIR is withdrawn, this matter will become infractuous.
Yeah, but no, my lord, once the entire thing is quashed, then the question of withdrawing the FIR will not come also. So, my lord, I have no objection at all. If the matter is decided, quashed on the basis of the settlement arrived at between the
But
parties.
then the settlement speaks about withdrawal, it doesn't say about quashing.
But my lord, the only reason why I cannot withdraw the FIR is because lordship is granted stay on investigation of the matter, my lord.
No, that will not forbid you from withdrawing. What is the problem in it?
My lord, in the police station, I am sure, my lord, they will say that the matter is subject before the
That is
court.
a presumption, mere presumption. But then is there any legal bar?
They should not be a legal bar as
take
such.
any action which basically will be in violation of the state. But then if you go for an action which falls in the line of the interim order. What is
The only problem with that, whether the police will allow me to withdraw when the matter is sub judice before this honorable court. Of course, there is no legal bar as such.
Of course, that
Well,
remains.
otherwise, my lord, on the basis of the settlement, the matter can be quashed also, but it may be closed, my lord, since.
It's up to you. If you say that it can be closed on the basis of the settlement,
Yes, my lord, we are on the same page on that.
there is no problem.
There is no problem.
Okay. Hard counsel for the parties. Then just say this is an application under section 482 CFPC seeking quashing of FIR dated 13/2/2023. How many FIR there?
There are two FIR.
There are two FIR. One, the first FIR and counter FIR. The first FIR, counter FIR, they've been forwarded to the court and the court has quashed them. So now the remaining FIR is only that.
No, but then here it seems this case has been registered on the basis of two FIR, 13/2 and 21/12.
The two FIRs have culminated into registration of one case.
This FIR,
13/2.
there are two FIR.
13/2 and 21/12 of
No,
2020.
21/12 is it's still there.
Lordship, it's on the basis of these two FIRs that this
Both
case
the
is
FIRs,
registered.
are filed by.
No, Lordship,
Hello.
the first FIR 7/2/2023 was filed by by this petitioner Exide. Petitioner Exide
Lordship,
Company Limited.
We are challenging two orders, 13/2/2023 and
That is
21/12,
exactly, madam.
which
That is the
filed
question.
by-
I do not know what. See,
No,
now
Lordship,
things
it's
are becoming.
Yeah, they are challenging the two FIRs.
Yes. Then where is the first FIR? Just show us where is the first FIR.
First FIR is 7/2/2023.
There is no 7/2 here.
Paragraph.
There are two FIR only 21/2 of 2023 and 13/2/2023.
Paragraph 4, page 6, Lordship. Page 6, paragraph 4.
What does it say? No, is it? You come to the prayer. Why you are coming to this?
Your Lordship, this FIR was filed by us. Your
Which
Lordship.
one?
This the one which he referred to.
No,
in
but then
page
there is
16.
no prayer with regard
No
to that.
prayer with regard to this. Yes,
So
Your
it
Lordship.
seems you are confused, Mr.
No,
Karni.
no, Lordship. This FIR dated 13/2/2023. It has been tagged together with FIR, first FIR.
So that is what. But then who filed this 13/2?
13/2, it was filed, counter FIR filed by the Pongrove agencies.
I filed.
By the Pongrove agencies.
No, my lord, we have already entered into a settlement now, so.
Yes, Mr. This both the FIRs are filed by you.
My lord, initial FIR was filed, my lord, where my lord.
This case was registered on the basis of this.
Of both of them, my lord, both of them. So ultimately, my lord, what my learned friend wants is quashing of the case. Well, there may be two FIRs. Ultimately, the case which has been registered on the strength of two FIRs.
That is all right, but
The second FIR supplements the first
We are
FIR.
just recording the fact of the case.
Yes, my lord.
So that's what. Just tell us.
So that is different. That is they registered non-FIR.
It is 21 to 2023
That is this is a non-FIR.
and 13 to 2023 lost by the respondent number 3 or 4. Who lost these things?
My lord,
3 and 4.
4, my lord, 4.
Lost by the respondent number 4.
My lord.
Sure.
Your Lordship.
If there is any mistake, that will be because of you. Say
My number 4, my
Number
lord.
4 is authorized.
I am the authorized signatory of the agency.
on the basis of which, and then this just say the last line. Just say the last line. The FIR.
This is different.
FIR did it so and so and so and so. There are two FIR. Yes. And also Mola IPS case number, and also the Mola IPS case number 031/2024, which was registered basing on the said aforesaid FIRs. Stop. Give a paragraph. It has been submitted by the parties that it has been submitted that the parties. Then who is respondent number 3 here?
My lord, 3 is the agency, my lord. It is
owned by you.
My lord, she's my daughter, my lord.
Well, this present petitioner is not a party here. This present petitioner is not a party to the settlement agreement.
My lord, it is signed by respondent number 4, my lord, who is the authorized signatory of the agency, my lord.
What about the petitioner?
The petitioner is Exide Industries, my lord. The person who's filed, he is one of the representative of Exide Industries.
But the petition doesn't say so.
My lord,
the cause list of the petitioner is an individual name.
His entire, my lord, he has come before this court, my lord. Mr. Jayanta is an employee of Exide Industries. He is the one who's initially filed the FIR based on the basis against which we file a counter FIR and a subsequent FIR.
Is he a signatory in the?
No, Your Lordship.
He's not a
Your Lordship,
signatory.
the petitioner is just a
The problem is that
representative.
this court may pass any order. You see, tomorrow the party will come and they will challenge it. That is what the problem is.
Your Lordship, the petitioner is just a representative of the company in Shillong, Your Lordship.
That is all right.
Because
But then once he has instituted this case in his individual capacity, he should have been a secretary to this compromise. It seems like it is somebody signed by some Agarwal. This was what was the learned counsel appearing to the parties submit that the dispute between the parties which resulted in the registration of the Meghalaya IPS case number so and so has been settled, and the parties have entered into an agreement of settlement dated 27th June 2024. Stop. The agreement has been brought into record by an affidavit filed by the respondent number 4. The learned counsels also submit that the FIR in question you just say FIR dated so and so and so and so without writing question, and the proceeding after Meghalaya case number so and so. 331 2024 under section 500 actually. Okay. Can be passed on the basis of the said FIR. Yes, Mr. Kharmi, what do you say?
As per my instruction, only those two FIR they have been forwarded to
So you have no objection to this?
Regarding settlement, we don't have any objection.
Okay. Mr. Kharmi, learned GA appearing 1 and 2. Earlier you said learned counsel appearing for the parties. Now you just said learned counsel appearing for the petitioner and the respondent number 3 and 4.
3 and 4.
Yes. Okay.
The state, Mr. Kharmi is one.
For the state. Okay. Then Mr. Kharmi. Then now you say Mr. Kharmi, and state counsel has also no objection to the prayer made by the learned counsel for the petitioner and the respondent number 3 and 4. The paragraph. Just in view of this submission means the FIR dated so and so and so and so, and the proceeding of so and so, proceeding of the whole appeal on the so and so, stand quest. This criminal petition stands allowed.
Yes. Much obliged.
Highly obliged.
Daily causeless hearing item number 6.
Yes, what is this?
My lord, we had filed our show cause cum objection on the last date, my lord. And copies had been duly served to the respondents, my lord.
In the miss case?
Yes, my lord.
Yes. You are not filing any objection?
No, my lord, I am not filing.
Oh, you are the respondent?
I am the one of the respondents.
What is your objection, madam?
My lord, if the matter can be taken up after 2 weeks, my lord, only on account of bereavement in the conducting counsel's family, my lord.
Yes, in the miss case, just say miss case 51. The learned counsel for the opposite party one submits that an objection. The matter has already been filed. You have received a copy of objection, Mr. You have received, yes. Mr. Namri, learned counsel, the applicant acknowledges the receipt of the copy of the objection. So it's the request has been made on behalf of the opposite party one to take up the hearings of the matter after 2 weeks. The paragraph, the request made is granted, list this matter after 2 weeks. Then in the main writ petition also, just say list this matter after 2 weeks. The main writ petition.
Item number 7.
Yes.
My lord, this matter relates to the so-called restoration of the lost same ship, Himar and Mesau same ship. It was restored in 2017 by the impugned order. So that is the issue involved here.
What is the impugned order?
The impugned order, my lord, the restoration or creation order, we can need page number 153 of the writ petition. was passed on 24th February 2017.
Page 153.
153. 153.
Yes.
My lord, the operative portion may just come. It's a very lengthy order. Page number 164.
So no requirement to go through the entire order.
My lord, I will come to the lordship permission. I'll
It will be advisable to
show
go to the entire. It will be advisable to go to the entire judgment. Oh,
Definitely, if required, you will have to. Definitely, you have to appreciate the fact.
otherwise we will miss out.
It's all right. Let him point out the things and all. You see, if you have anything, then when you address the court, then also we can go through.
Well. So page number 164, my lord, to show the operative portion of this order passed by the District Council.
Yes, sir.
Well.
Yes, 164.
Well, page number 164.
Yes.
The last paragraph, my lord. We just read up.
Yes.
My lord. Thus, from the submission put forward by the petitioner backed by the materials on record, we feel that weight of the case is in favor of the claim put forward by the petitioner, and therefore we are appalled that this missing state of Nomen-Sao Sameship is hereby recognized, preserved, and restored to its pristine glory and original status as the Nomen-Sao Sameship, and that only a male Atal of Khasi Muling community belonging to the same Nongpa land is eligible to be appointed as acting CM, Deputy CM of this CM-ship. Further, we uphold, recognize, and approve also that only the male Atal, that is the Mantris, the Lingdos, the Konghors, and the Hitmen belonging to the Khasi Muling are the eligible electors to nominate, appoint the same Deputy CM of Nomen-Sao Sameship as per the customary laws as provided in paragraph 3, subparagraph 1, clause G and J of the aforesaid 6th schedule and as per articles of the Constitution. The notification dated 2009 orders, notification letters, and other correspondences and be relating to existence of the Hima Right Mind Sao or Right Mind Sao Sidarship are hereby set aside and quashed with retrospective effect to protect and safeguard the customary practice, says and the messages. So if I gather, my lord, here, they restored the lost sameship. Number one.
Bill. This is bill has been also been set aside.
My lord.
Bill has been set aside by the.
My lord, by this impugned order.
See,
I challenge all this, my lord. Now, if I gather from this operative portion, I can gather that the lost sameship was restored. Number one, in view of this restoration, they also decided, District Council decided who entitled to occupy the chair of the Chief Deputy CM and others. Number three, in order to do that, they have set aside the earlier notification 2009 as well as the bill. My lord, this would be the first occasion where the executive body has set aside the bill pending before the floor of the assembly. Now, my lord, my primary grievance here, first grievance is that before passing this order, opportunity of being heard was not given to him, to the petitioner. That is number one. Number two.
You are not a part of this proceeding.
My lord. What happened in this case, my lord?
Yes.
After remand by this Honorable High Court, matter was taken up.
There was a previous round of litigation.
Previous round of litigation was there, and this Honorable Court, earlier court, the High Court, held that opportunity will be given to all the parties and take a decision. So the Executive Committee in charge Ilaka in 2015 heard the matter, issue notice to both the parties to appear and submit the detailed documents. Both the party appear for the first time, single time, and thereafter the Executive Committee resigned from the post of the executive member in 2016.
Who resigned?
The executive member, Mr. Ibla, who was in charge of the executive member, Ilaga, has taken up the matter, issued notice to both the parties, opened the
And
record.
then he resigned.
And thereafter he resigned.
Then what happened?
Thereafter, my lord, the petitioner and other parties expect that the newly appointed or elected in charge Ilaga, or district council, we can say in short, is expected to give opportunity to the parties.
No,
now,
but the
without
notices were issued to you. Then?
Notice was issued to us. We appear. So also the private respondent also appear.
So you have taken part then?
But that it is true. Now, on that day we appear and the matter was taken up. It was not a conclusive one. And the party was expected to go for further proceeding. Now, in the meantime, he resigned. Now, thereafter, new in charge Ilaga executive member was appointed by the district council. He did not hear the matter. Now, without hearing the matter altogether, the CEM and the executive in charge trade, who has no business with the Ilaga, has passed this order. Now, the law is very clear. Well, I'll show the record here.
High Court remanded it.
Yes.
To be decided by whom?
By the district council, executive committee.
Executive committee.
Yeah, executive committee.
Now, this is a decision by the executive committee.
It is the executive committee, my lord. But normally, my lord, if it is a trade matter, the executive committee trade in charge is always there.
What is the previous the order of the High Court?
There you come.
See, once High Court, there is a direction of the High Court, then it will go strictly by that.
Well,
so,
may I come to that? 11 portion.
Yes, one of you can go. Yes.
My lord, we come to page number 138.
138.
Lordship, just my colleague will be here for some time. I'm coming back.
Yes, sir. Yes, sir.
138, madam. This is the order passed on 10 March 2015. And the operative portion may come. Page number 143.
Page 143.
Madam. This is the interim order, 143.
Of the High Court?
Madam.
But then, okay.
Madam. This is the interim order, madam. Page 143. 143, Lordship.
There's an interim order?
Yes, interim order also. So,
no, but then earlier case was this thing.
My lord, then I will come to the final order of the High Court. Page number 144, my lord, straight away.
Okay, now in interim order, whether there is there any requirement that we should go to interim order? You want to show something from the interim order?
My lord, I just want to show that there was an interim order when they approached before this court, only to that extent. Now,
who was the petitioner in that case?
Well, they are private respondent number 7. My friend, Mr. Nobri. Now, this is his petition.
What order was under challenge in that?
He challenged, my lord, there was a notification for election. And he said that that notification for election is illegal because the issue of the creation is still pending. So without settling the issue of pending, the issue of the creation of the restoration of the same ship, election cannot be conducted. That time, my lord, the bureau also kept pending. Now, the final order, page number 44 onward, 144 onward.
Yes.
My lord, I'll come to the operative portion, page number 149.
Yes.
Para 2, may I start, madam?
Yes.
Mr. Bino, learned counsel appearing for and on behalf of the petitioner submits that the petition is pending before the exit committee, KGDC, pertaining to the matter to decide the status whether it would be right mensal or right mensal same ship. But the executive committee, KGDC Shillong, did not take any steps in spite of the order passed by this court on such and such. The learned counsel further submits that there is new development because the KGDC Shillong has issued a letter dated such and such 15 for hearing on the said petition. But due to the pendency of this case, hearing could not take place. The Learned Counsel also further submits that since the KGD Shillong is willing to hear the parties, the matter can be disposed of. Ms. Sansa Sansach submits that she could not file the counter till date, and she has also consented that if the matter is disposed of, she has no objection. Considering the submission advanced by the Learned Counsel at the bar, the Executive Committee Shillong is hereby directed to fix a fresh date and to hear the parties and to dispose of the matter expeditiously. Accordingly, the notification 2015 is hereby quashed. Let the Executive Committee KJTC Shillong complete the whole exercise within 3 months from the date of receipt of this order. So this was the order.
Now that notification for election was set aside.
Set aside. We failed to, my lord, participate in that litigation. However, that is gone. Now this was the order.
Oh, so you did not take part?
I was not there.
You were a party there?
My lord, I'll just see the post. My lord, he was a party. He was a party. Perhaps he failed to appear. Perhaps he was a respondent number 6.
All right.
Now, if we go by the direction of this honorable court, there would be a fresh hearing, fresh decision
on the issue of the election.
Yeah, on the issue of my lord, the issue pending restoration matter.
Restoration of
the same chip.
The restoration of the Elaka, which was there in.
Yes. Yes.
Till 2009, this Elaka was in his favor. The whatever.
Yes.
It was called right.
Yes.
So right means so that till 2009 he had no grievance. Now that right means it continued from when? Till 2009?
Very short time.
No, when it right means came into existence.
He married me from 1960s.
Okay. So it means it was there for quite
long time. And district council also recognized that one. Forward notification was
position changes only in 2009. Now 2009, what happened? Your Elaka merges with his Elaka, or what?
My lord, what happened? This was undisputedly one of the same ship, but in 1876 it was lost because of the no successor. According to custom, only one particular
right Minsao.
Yes.
No, but the right Minsao was in existence till 2009, isn't it?
Hima right Minsao same ship was in existence till 1876.
Now, this case, so far as you are concerned, what is your cause of action? What is the original day of your cause of action?
My lord, the impugned order. Now, what happened, my lord, briefly?
Impugned order.
My lord.
So prior to the impugned order, you had no grievance.
Yes.
So far as the Elaka is concerned.
Yes, so far as the right means how sitarship is concerned. Now, what happened, my briefly, with lordship permission, Hima right means how same ship was one of same ship like other. It existed till 1876. Now, on the death of the then king, the chief, there was no successor, no one to succeed the chief. Therefore, it was continued. The jail was emptied. It was continued, and during that time, the so-called the relation of that king.
What is the status of a same ship minus its chief?
Therefore, my lord, it was ceased to exist. It was ceased to exist without the chief.
The same ship disappeared.
It disappeared. Now, in view of that, my lord, the relation, so-called the close relation of the then chief came forward and claimed for restoration during the British time. The British Governor General has passed an order that no, your kingdom has lost for a long time, so we cannot restore it. The order was passed. Matter ends up. It was continued. India achieved her independence. It was continued, and because of this lost kingdom, these villages, there was no head. Every village they exist in its own way. Therefore, they merged.
They all became separate administrative.
Units. Yes.
They had their own bodies.
Own bodies, and for the time being, my lord, it was overseen, supervised by another neighboring same ship. And later on, my lord, they came together.
Neighboring same ship means
neighboring same ship.
Neighboring same ships can have administered those areas which are not under their control?
My lord, it is a matter of concern for, they are not claiming, the neighboring sameship did not claim the rights over this area. But for temporarily, they overlook, supervise to some extent, administration purposes for certain years. Later on, these villages came together, and since the sameship has lost forever, therefore, let us establish as a sidarship and continued. And it was continued, and district council recognized it.
So
And
how many sidarship came into existence after disappearance of the same ship?
but after disappearance, more than a year, more than 100 years.
No. How many sidarship came into existence?
Yes.
See, you said that there was a seamship prevailing, and at a certain point of time, it lost its successor.
Yes.
So, in absence of successor, the same ship also disappeared. Now, this same ship was replaced by various separate administrative units.
Yes, villages.
Okay, which were born under the customary law.
Yes.
To administer their own separate units. And then sidarship also came up.
Yes.
Now, the question which this court is putting to you is that under that CMC, the CMC which disappeared,
yes,
how many sidarship came into existence?
Only one.
Only one.
Only one. Only one.
So it was only a change of name.
A change of name,
to sidarship.
my lord.
And then what is the name of the sidarship which came into existence?
Human right means house starship.
That is you.
That is me. And other repetitions are
And
villages.
then you continued.
We continued.
This
For 20, 30
administrative
years.
unit
Yes.
of Himaraj Minshao,
yes,
the sidarship, continued till 2009.
9.
Now 2009 a notification comes.
Yes.
By what happened? Your sidarship
My lord,
is what? It
my
is-
lord, 2009. 2009, my lord, may I just take that 2009
The
notification.
cause of action, that means 2009 is a cause of action. Now 2009 notification comes which replaces you.
My lord, only 2000, my lord, this 2017 replaces my sins.
Then what is 2009 then?
My lord, 2009,
See, this court has not got the fact till now. That is what the problem. Until and unless.
my lord, page 80, Lordship kindly see, page 80 is the appointment of the Sirdar of the Sidarship. Page 80, that is 2009.
It was the High Court order which we have done.
Yes.
So that will make the thing clearer. 84. Till now, this court has not got the grip of the fact.
My lord, page 80.
80.
80, my lord.
Yes.
Well, Lordship kindly see, it is hereby notified within the right Mensau Ilaga, formerly known as the Nomensau Sameship, that the Executive Committee KGTC is pleased to recognize and approve again, it says again, it as one of the Ilaga under the administrative control of the KGTC. Therefore, the Nomensau Sameship as well Khasi State is recognized and confirmed as the right Mensau Ilaga, and its office will be at Langbi, such. At the same time, the Executive Committee is pleased to appoint Mr. Hindro Samaka as the Sirdar of Right Mensau Ilaga. He is a Sidarship who shall run the administration for the period of 5 years according to the custom and usages of the Ilaga. So by this formal notification under the Act, District Council formally recognized that this is earlier the laws, the Nomensau Sidarship is recognized as now as a Nomensau Sidarship. And Sidarship chief was appointed. This was challenged by my friend.
Now, this has been recognized as a CMship only, not Sidarship. Therefore, the Nangminsao CMship, Restaurant Khasi CMship, is recognized and confirmed as the right Minsao Elaka.
Yes. Madam, Ilaka Lordship, therefore, the second paragraph is clear.
And
because in the
always
Samaga as a Sirdar, my lord. If it is the same ship restoration, there cannot be a Sirdar, it should be a chief. And they are not disputing this one also. Because of that, they challenge. If it was a restoration of the same ship, they won't have a challenge.
Now that is a recognition of a same ship, but then appointment of Sirdar.
Sirdar, my lord.
So there is inconsistency.
My lord, therefore, in substance, it was the recognition of the Sidarship and appointment of Sidarship. Therefore, the
Which way we take what is wrong and what is right?
My lord, that was not disputed. Since they are also not disputed, they challenge
the issue of the use of the word same ship and Sirdar has no relevance so far as this present dispute is concerned. It can be ignored.
My lord, that is the background of the case.
No, that's all right. But then it is not a serious issue here.
My lord, it is one of the important issue because under the Act, 1959 Act, the District Council can recognize any administrative unit as a ilaka. And once, my lord,
ilaka even same ship can be ilaka.
Same ship may be ilaka. My lord, Sidarship may be ilaka.
Yes.
Yes. Therefore, here the 2009 declaration is a declaration of the Sidarship ilaka, saying that same ship, nomination same ship was lost. And therefore, we recognize the nomination Sidarship ilaka as Sidarship as a Sidarship under the Act. And this was challenged.
It seems it is very confusing that whether it is recognized as same ship or Sidarship.
My lord.
From this notification, the first part says that it is same ship.
Because the word ilaka creates some confusion, but substance of the case.
Ilaka can refer to both.
That's therefore, my lord. Refer to
there is no problem in it.
My lord, refer to both. Therefore, they also understood. My friend understood that it was not the restoration of the same ship. If it was the restoration of same ship, it was in his favor. There was no occasion for him to challenge this before the High Court. But since he knew very well that it was restored, it was a.
So he challenged that.
He challenged.
I challenged it for the High Court.
Yes.
So what was the purpose of challenging? Why did you? Why are you aggrieved by this?
We'll kindly read again.
Yes. Page 80.
Therefore,
Yes.
nominal ownership in bracket, worthwhile consistent.
Yes.
Is recognized and confirmed as a right. So this particular citizenship which has been there has been converted into a right. That is why we are agreed that. Because, Your Lordship, their recognition came only in 2009. There was no records in the past that they had been running it. That is why we come before the High Court.
So by right means it becomes a Siddharship.
Becomes the tenure also, Your Lordship, of the chief is not for life anymore. It's only for 5 years.
Okay, that is the second part of the order is concerned. But then, so far as that refers to the word raid is concerned, by becoming right, it means it becomes an ilaka. I mean, it becomes a Siddharship.
The Siddharship, Lordship is well aware, is an area which are governed by the British time.
Now, essentially, what is the difference between a same ship and the
I
right?
think that a Lordship through one judgment passed by this court.
Because it is very important to understand the fact here.
Yes. Is there in the Act also, Your Lordship? What is a Siddharship and what is a Samship?
Yes.
I'll take Your Lordship to page 5, Your Lordship, of this judgment.
Page 5. Is there any pagination?
There is no pagination. Sorry. From para 12.
Para 12. Yes.
Now we'll go down, Your Lordship, at number 2.
Yes.
Definition and interpretation.
Yes.
In this Act, unless there is anything repugnant in subject matter or context, or the context otherwise requires.
Yes.
Right means a distinct unit within Simship, Doloy, Lingdorship,
Yes.
Sirdarship, or Wahadarship composed of one or more villages.
Yes.
Next page, Your Lordship. For the definition of Simship. Simship means those areas known as Khasi state prior to the commencement of the Constitution of India. There are 25 in number as shown in appendix.
So distinction is clear. Right is a part, unit under the same shape. No, but then just you see, when it refers to an ilaka, the mere mention of word right will convert it to right.
We'll definitely turn that particular ilaka into a Siddharship.
That is a lowering of status.
Yes, lowering of status. Absolutely right. And the definition of Siddharship also is defined.
That is okay. That is there in the act. Why you have taken to this decision?
It is in the act, madam. It is in the act.
You could have taken us to the act itself. Anyway, it's all right. Thank you.
So, my lord, being agreed with this impunity order 2009,
yes,
my friend has challenged, and the Honorable High Court passed the order, page number 84. Order dated 18 October 2010.
Page 84.
Well.
Yes.
Well, an operative portion may come to page number 85.
Page 85. Yes.
85. It says, under the circumstances, we permit the petition to make a representation to the Executive Committee of the KGTC for reconsidering the notification 2009. The Executive Committee will hear the matter in a manner that it thinks appropriate, and after hearing the petitioner, it will take a fresh decision on the issue whether the nominal same ship should be restored to its original status or should continue as a right. We make it clear that we have not gone into the merits of the case and we are not interfering with the existing notification. They didn't interfere. The hearing should be given to the petitioner within a period of 2 months from today. The Samaka will also be entitled to a hearing in view of the fact that petitioner is being granted a hearing. Executive Committee will then take a decision within 6 months thereafter. So this is the order. Now,
then why, if this court found it not worth to interfere?
Yes.
So why there is an order to reconsider it?
Madam, therefore, the only grievance is that this 2019 order was issued without hearing him. So therefore, the Honorable High Court has given him an opportunity. Okay, you file a representation.
You see, the direction was passed. Reconsider. We understand that aspect.
Yes.
We are not prepared to elaborate it more. We got it. What you are trying to say. Now the question of the court is that once the court has decided that they are not interfering with this order,
exactly,
then what this reconsideration will? That means like you remain at the mercy of the executive committee. If they want, they will do it. But then they are not under legal obligation.
Right.
To go to.
Right. So
is it something like that?
My lord. So 2019 order notification remained the same. Only the window was open to him, and we can say both the parties to receive the hearing from the district council on his representation.
Then what happened after this?
After this, my lord.
This issue has.
My lord, 6 months was given. 6 months were given to him. He did not appear. He did not move any application before the district council within 6 months. Lordship, kindly that one see page 86. 86. Well, after 6 months, he came up with his application.
Expectation was to complete it by 36.
Yes. And he did not do that. So after expiry of the time given by this honorable court.
Page, you are referring to
page number 86. He had put up this application. Madam.
This is by him?
By him.
Auxilius CM
yes.
Nongba.
My lord. Yes. He is the acting chief now. That was his application. Thereafter, what happened?
This is dated 21st January 2011.
Yes.
Okay.
Yes. And thereafter, my lord, he had put up another application, page number 90, in 2013.
2013.
13.
That means that after the period,
yes,
of the.
So this 2000.
By that time, that 2013 also it was not decided. It remained like that. So what was the observation was there in the High Court order? It was ignored.
Yes. Okay. He has to file a representation. Okay. Since he did not file any representation within that time.
But then what is this page? It is page is not a representation.
But it is, my lord, as good as a representation. This is the first application he put up after the High Court order. Because the High Court has given file a representation within the stipulated time. He didn't do that. So after expiry, he came up with this application. So perhaps the district council, seeing the expiry of the time, did not take up any matter, thinking that the issue has been resolved already. And in 2013 also, he put up another application, page number 90.
Okay.
Well, and again, same repetition he made in October 2013 again, in page number 94.
Again, another representation.
Another matter.
So representation after representation.
Yes.
So this
He was trying to revive.
Page 94 is dated what?
Page 94 is dated 25th October 2013.
2013.
So he was trying to revive. He waived his right already, and after waiver, he tried to revive again with this reminder one after another. And I would show, with Lord's permission, the same thing, page number 85 or so. Another reminder.
What is that 1810? What? See, in this page 94,
yeah.
Order of High Court was enforced.
My lord, much expiry. He is enclosing the High Court order.
That earlier, which
earlier. Therefore, district council did not take any steps because the matter was already waived by him and it was not proceeded further. He was trying to now revive it.
Wait just a minute. No, anyway, then that means all this thing fell under that order for reconsideration.
Yes.
And then what happened?
My lord, and page number 97, district council fixed a date. My lord, page 97, for hearing. Since he has put up again and again, therefore matter was fixed again. On 16th December 2013. Page number 97.
97. And what is 95? 95, 96 is another representation.
Another representation filed by my friend. Yes. So in response to
Page
his...
94 is 25th October. Page 95 is 30th October.
Yes.
Okay. Now this is for... No, okay. This page 97. Okay. Then what happened?
My lord, thereafter it was not taken up. Therefore, page number 99, it was refixed again. Page 99.
Yes.
Later dated, my lord, 6 January 2014.
Then again, what happened on January?
My lord, thereafter, the petitioner here, one of the petitioner has also filed his reply, page number 101.
If you say page 99,
right.
It says due to adjournment sought by one party. Now, who is that party? There was a difficulty in disclosing.
99, my lord. Lordship, page 99.
Page 99.
Okay.
This district council refixed the date of hearing because of adjournment sought by one party.
But I'm not aware whether...
There is no disclosure of who is the party.
Yes. Which party sought the adjournment?
So there was a secrecy.
One of the adjournment sought the adjournment. The record says so. And from our side also...
Mr. Nangri's work, isn't it?
My lord.
Yes.
My lord, page number 101. My party, one of my party, Siddharship chief has filed his reply.
This is reply filed by?
Filed by the writ petitioner, one of the writ petitioner.
Now, what is your opposition to their thing? Why you are opposing?
My opposition was...
What is your status? What is your locus?
My lord, my locus was that, my lord, the same ship ceased to exist long ago, 100 years ago.
Who are you? I mean, like, what position you were?
My lord, I am the chief.
Of the
chief of the Siddharship.
Siddharship.
Now, 2019, formal recognition was given to the Siddharship. I was
So
appointed.
if it gets converted to CMC, you lose your position.
Oh yes, yes, and not only me, other villages also. Village
So this
headmen
is
are
your
fine.
shokos.
My lord. Thereafter, my lord.
This is dated what?
My lord, this date.
14 January 2014.
Yes, my lord. And my lord, we come to page number 112.
What is that 112?
112 is a legal notice issued by my friend saying that the district council did not take up the matter.
What relevance it has?
My lord, my lord, showing the journey of the contention between the parties. And lordship, can you see? Page number 115.
115.
15, man. The writ petitioner number 1 appointment was, my lord, given again, 2014.
It was for acting chief.
My lord. And thereafter, my lord.
You were chief and then you become acting chief.
But since the expiry of the term, there was a reappointment as acting chief before the full-fledged election. And subsequent to 2015, there was a full-fledged election again for the chief, for which my friend challenged again.
This was done because of the pendency of that.
Yes.
Apparently for that reason.
Apparently should be, my lord. And lordship may kindly travel again to page number 117.
So this 115 is not under challenge, isn't it?
Yes.
It was never challenged.
No.
Yes.
Now what happened, since the High Court has given a time to the petitioner to file representation, he did not file it, and subsequently he filed one after another, and district council of course issued notice to the parties. Now the matter was seized by the executive committee, and they introduced appeal. And the bill was passed on the floor of the district council.
Matter see, earlier order by the High Court was, direction was to the executive committee to dispose.
Yes.
So definitely it was seized by the executive committee.
Executive committee, and executive committee was entitled to seize the matter within that time given by this honorable High Court, the Guwahati High Court. He did not come forward. And much after delay, he came forward and filing one after another, and district council and executive committee issued notice to both the parties. And my lord, before hearing his representation, the matter was seized by the district council, and the bill was passed. And when the bill was passed, lordship guide is the page number.
So before that decision was taken, a bill was passed.
Bill was passed. Because once my lord, my humble contention is that once the time given by this honorable court, by the honorable Guwahati High Court is expired, it is not binding to this council.
That bill was in your favor?
Oh, the bill was in my favor. The bill was clearly contemplates that there should be a Siddharship. And the bill was passed, bill was forwarded to governor for his assent, and governor has reverted back with certain remarks. Lordship kindly see page number 117. So the entire issue, my lord, once the time given by the honorable High Court, the High Court was lapsed, it is no longer binding to the executive committee to take a decision. However, filing representation one after another, therefore, the issue notice. But issue was subsequently seized by the district council, bill was passed.
The passing of the bill, was it an act of contempt?
My humble submission, well, it is not. If it is done when the writ petitioner came forward within that time period,
so
and the issue is pending.
The passing of the bill was not challenged anywhere.
They didn't challenge.
They didn't challenge.
They didn't challenge.
They did not come up at that point of time saying that this house could not have passed the bill.
Right. They didn't.
In view of the pendency.
Right.
But then is it proper when a matter is sub judice?
But That is one thing, my lord. But it is
No,
not.
that is so far as the legality of the bill is concerned. But then until and unless, rightly or wrongly, if a bill is passed,
Yes.
then what is the courts available under law?
Now, my lord, now the bill was passed, forwarded to governor, his assent. Governor has reverted back with certain comments. Now the district council regulation says that.
So the bill has no enforceability so long it is asserted.
Yes, yes.
Now, what is the status of that bill then?
Now the bill, my lord, the moment it is reverted by the governor, rule says that it should be placed before the floor of the house.
Definitely, that is the
Now what they have done is that executive committee did not place the bill before the floor of the house, and yet, surprisingly, they set aside the bill. Therefore, Lordship invited Lordship
that
attention.
seems to be very unusual. But then a bill setting aside or keeping it alive, this is it not something that this very setting aside is an act of insult to the house?
My lord. Therefore,
I do not know. These are the queries this court is asking.
Right. Important
See,
issue.
like there may be many things. See, like many things, it may seem illegal, but then may not fall under the purview of judicial scrutiny. A bill passed by the House.
Yes.
Stand interfered by the executive committee. Now,
this is unheard of.
Just think which it's a you see, like basically the development takes place in one organ, the same organ in the right. Now, what can be the validity of that? How executive committee acts superior to the House?
Exactly.
Now, another thing is that since a bill has no legality attached to it in terms of enforcement.
Yes.
Now, even if we find that the action of the executive committee is illegal, can we restore the bill?
My lord.
You see, otherwise it has no valid entity. So far as the enforceability is concerned.
Yes.
Now, can we restore it?
But the moment if lordships satisfy the argument and set aside the impugned order, that means it
will be automatically revived.
And the bill will take its own course.
But then, can we set it aside on the ground that the executive committee had no power to interfere with the bill?
My humble submission, my lord. Executive committee definitely, since they don't have the power, lordship
admittedly, this is subordinate authority.
Exactly.
Now, can this court go into that aspect?
My lord.
And say it?
Well, my humble.
Because executive committee otherwise was acting on the basis of the authority given to them by the High Court.
Right.
In that particular case. Others also, they have the power, whatever the rules or the law permit.
Right.
But then so far as this case is concerned, the reconciliation was exclusively under the court's order. So they were judicially authorized. But then can we say that their authorization can be stretched to the extent that they can interfere with the bill?
Well, here no one challenged the bill. And District Council Executive Committee has travelled beyond its power, to the extent of setting aside the bill. Now, if Lordship set aside the impugned order,
the setting aside of bill, is there any instance, any other instance happening here or outside, be it in the case of any assembly or in the parliament, is there any instance? Do you have anything?
Well, I have done some research on this. I never come across. Because in the parliamentary process, Lordship is very aware.
Very unusual.
Very unusual.
If Parliament passes a bill, and the
cabinet overturned one night.
That is what.
Unheard of the thing.
Because the supremacy is of the House, isn't it?
Exactly. And it is not the case of my friend that he challenged the bill, saying that the Supreme Court.
After it's passed by the governor, then only we can challenge the act.
That is exactly the question. See, this court has already said it. That until and unless a bill receives assent, no legality can be attached, you see, like to it. So far as the enforceability is concerned. So until and unless it becomes enforceable, there is no cause of action for it, isn't it?
No cause of action.
But definitely. So that way you are correct. Now the question is that rightly or wrongly, the executive committee has interfered with the bill. Now this is something very unusual. Yes, madam, this is for you to clarify. Under what law it can be done?
Yes, Lord.
And do you stand up to defend that action?
Your Lordship, I think you would be in a better position to answer.
Yes. Your entry is in very right time. We are basically entangled with question. Here in this case, rightly or wrongly, it seems the senior counsel has not finished till now, but then the issue has come. The executive committee, rightly or wrongly, has interfered with the bill. Could it be done in law? Do you stand up to defend that action?
Pardon, Your Lordship, what was the question?
The executive committee, while passing the impugned order, appears to have set aside a bill passed by the House. Okay.
I've noticed
that. Now, what is the legality of that order? Just tell us. Give us under what law? This court has not heard any such instance anywhere. That where the action of a superior body can be interfered by inferior body. And now, I do not know, you stand up here to defend what?
We cannot deny the supremacy of the House. We cannot deny that. And this is one question which I've asked my colleague also. Of course, this order was passed after hearing all parties. It's not passed.
Just forget about all those parts. But that does not get diverted. Just say, could this order be passed by the executive committee? And if in the event it appears that they have passed the order.
Yes.
Okay. What is the validity of this order?
Insofar other facts and figures is concerned, it's in accordance with law. But insofar that one point where the executive committee has set aside the bill, perhaps that is, I'm here to speak what is correct, Your Lordship. I think the executive committee have acted beyond its bounds while
that part of the order has
that part of the order.
This part of the order.
That part of the order, but the other part of the order is okay. Now, so far the bill is concerned, so long it doesn't get the assent of the governor, it still remains a bill, unenforced. It will be coming into force on the assent.
No, we are not going to determine the right of the parties on the basis of the bill.
That part of the thing I think is incorrect.
But another aspect is that the bill, which was interfered with by the executive committee, rightly or wrongly,
yes,
the petitioner cannot be aggrieved by that. Because no right is agreed on the basis of the bill.
Yes.
So this court may not interfere at their instance. Because bill gives no right to it.
Nothing.
That is another technical part. Now the problem is that these are all remaining queries. What is the answers? Answer in law. And we want a correct answer in law. Now, so far as your submission is concerned, we can record it. We can say that senior counsel has said that executive committee has exceeded its limit. Okay.
And so far that point is concerned.
Yes. But then why should we do it here at the instance of the petitioner? Because petitioner, no right has been accrued to the petitioner. So he cannot stand up and say that I am aggrieved, I am not aggrieved by this.
Agreed.
It is none of it. Agreed. So it may not be proper exercise by this court also to say that executive committee has done it wrongly. Though you have candidly admitted that.
Lordship, under 226, in fact, when it comes to such decision by a body like the executive committee, it will have to be very cautious to interfere when there is no absolute violation of principles of natural justice. Here, the question is that they have been heard. This is not a matter which is just overnight. It has been long pending since last many years, maybe a decade or two. And the writ petitioner is saying that they have not been heard.
Yes, sir. You are now, Mr. Sangreshu has not finished. So this will be all your defense when it would come in your replies.
I'll come with facts and
because just to get the clarification, because this court has not come across. Maybe you all and Mr. Sangreshu also has said that he has not come across the situation where bill stood interfered
by the executive
committee. When the House
by the
passes
executive state.
The subordinate things. So that is why this is what they say, like the question was there. That is why we required.
I have to candidly admit that that part of the direction.
Because we cannot stand up to defend that order. Cannot stand up here to defend that. I don't think, because you represent the district council, isn't it?
Yes, Your Lordship.
If you do that, then you will be undermining your own authority.
And admittedly, yes. At the end of the day, I am an officer of the court. I cannot make wrong submission also.
No, and that is, see, being a senior counsel, you owe a duty.
My duty is to do towards the court also.
Definitely. You
I cannot just.
Definitely, that we understand. And that we are confident you will be doing it correctly.
Lordship, I have a small request.
Yes.
There's an important issue at Court number 2 regarding Mines and Mineral Act of 1957. If it can be adjourned to maybe to another date, my audience is required there also.
When it will be convenient?
Next week.
It's like to be becoming quite interesting now because of this. So your presence will also be required.
Yes, Your Lordship. Maybe next week, Your Lordship, if they are okay.
Yes, Mr. Namavi. There will be many things you will also have to reply. You do not know, sometimes it may sound that court is traveling to certain areas, but then it is the argument which takes court to those areas.
The petitioner will have to stand on his own leg. His strength and weakness is
There are two aspects, you see. The one thing is that this court is very much aware of the fact that the bill has no enforceability in law, so long it is assented. Again, at the same time, the question comes when an order which is under challenge before this court, apparently, you see, like involves the question of interference in the bill, then what would be the duty of the court in such a case? Can it ignore that part also?
Well, Your Lordship, insofar the bill is concerned, that has not taken the force of law. It's just been passed by the House. But insofar that point whether the EC can set aside and quash it, it's something.
But then why there was no modification of that thing by your executive committee? At least they could have modified that part of the order, or they do not have the power to review their own order.
They don't have
that. Also another difficulty.
We had seen this.
After passing of this review order, whatever the bill that was passed in my humble submission, it has become redundant because can we see the name of the bill?
Yes, to some extent you are correct. You see, that is okay. But then say supposing
after the restoration, if a bill has to be passed again, it will be on the basis of bill of a steamship, not a surdarship.
That is it depends on the wisdom of the lawmakers.
What is the consequence of setting aside of a bill? Would it mean that House cannot adopt same bill again? Is it not that this will give rise to many questions and this will remain forever until and unless some view is taken on that?
Yes, very vital issue. Vital issue.
The other day,
seems Mr. Anyway, we'll have it after
yes.
go. There is no use losing time here and there also.
Yes.
So just say at the request of the London Senior Counsel, appearing for the District Council, this matter after a week. Interesting, we'll just say. Earlier, this court was thinking, it's okay, Mr. Kinta, you can leave.
Much obliged.
Earlier, this court was thinking that this is merely a change of name, but then it is not that.
Yes.
It appears to be.
Yes. Deeply obliged.
Good day, Your Lordship.
Item number 8.
You want it to be retained, Mr. The decision here, or you want to take it back? Yes.
Well, this is the matter, the chicken curry matter, my lord.
Yes.
I was required to take instruction, my lord. I have received instruction. The instruction says, my lord.
Please share it with him also. I think it will be until and unless you have something to.
My lord, as far as he is concerned, it was conducted on the same day, my lord. The test, the written test and the cooking test, both were done on the same day. And the reason being that he was the only candidate for that, my lord. And on the earlier round, the written test was held on 27/12/2014, my lord, and the trade test was held on 16.
How many candidates were there for written test and how many for the trade test?
That I think is there, my lord.
Now we have to, since you say that,
My lord.
so it apparently, since this court has passed an order, so
My
this
lord.
order remains.
My lord.
Now, if that instruction was required for the part of determining whether the petitioner was given the adequate opportunity as
to prepare
was to
himself.
other candidates, given to us. So in such a case, now we have to determine that whether the arrangement of examinations was for the administrative convenience or it is for the convenience of the candidates in order to give them opportunity to prepare. That is what is needed. So you have to give us the details of the candidates who appeared, how many numbers of candidates appeared, if your argument is in that line. So otherwise, then in terms of the last order, then that it seems that you see, like, he has not been given the similar opportunity because his initial rejection was because of your fault, not because of his fault.
My lord, that is true, my lord, but at this stage, my lord, the original test was held in the year 2017, my lord. Now we are in 2024. 7 years have gone by, my lord.
Now, what is the purpose of, you see, like, arranges these exams on these things? Are you taking that stand? That this
sorry, my lord.
The timing of exams.
No, he is taking, my lord.
No. He has taken that. Rightly or wrongly, we will just determine it. His contention is that he was asked to appear in exams on the board day, for both the exams on the same day. Isn't it? After written and then trade test on the same day. Whereas for other candidates, it was after some gap. Now, meaning thereby that the other candidates were given more privilege than him. Now, what is your answer to that argument?
But our answer, as I have submitted earlier also, my lord, that this is for basic cooking skill. Now, cooking skill is not something like we prepare for exam tomorrow, suppose math exam tomorrow or biology exam tomorrow, that we need some time to prepare for that.
No, but then the thing is that we can understand that. But then what would be your direct answer to that? That the gap of trade test and the written test, which was given, or which was provided for the other candidates. Okay, therefore other candidates, admittedly, the written was held on the other day.
They got around.
Was it for the purpose of giving them extra opportunity? What do you reply?
My lord,
what do you reply to that?
But our reply will be that was a structured, scheduled process, my lord. The original advertisement. So date was fixed for certain things.
What is the basis of that structure? What for? But this court has given you enough indication.
For any large-scale recruitment process, my lord.
So you have to take a stand. You see, like, we cannot come here on assumption. You have to give us a clear stand. That what for you? That means if you want to say that there was a presence of large-scale candidates, and you see, it would have been impossible for the authority to hold exam on the same day, isn't it, for everyone?
But normally, what happens, my lord, when the advertisement is issued, it is mentioned there that written test will be held on so and so date, interview will be held on so and so date, running test will be held on so and so date. So it is structured accordingly because there are a large number of candidates and to arrange everything.
No, then what is then what purpose? If you structure it, what is the reason for structuring it?
For administrative, to conduct it smoothly.
So that means that is what. So your plea is that if it is for the purpose of administrative convenience, then that would hardly matter him. So he cannot come up and say that there is no denial of opportunity. But then you have to take a clear-cut stand. And we will accept that once you can show that how many numbers of candidates appear there.
Well, so my lordship, I'll file a detailed affidavit, my lord.
Why to burden this court by filing so many affidavits? You obtain the details and furnish a copy of the details to him also, and we can argue with the basis of this. Because if it's a part of record, you do not have to file an affidavit for doing this.
Well, I get the points, my lord. Because in fact, I was also looking at how many candidates were there, but the instruction which I received.
Just to justify your argument that is for the administrative convenience, then you have to.
Obviously, it will for administrative convenience. It is not that we will give a chance to them to prepare or go for cooking class that time and learn cooking.
That is what. This court had already said, Mr. Chatterjee, that this court should have been a better candidate than him.
But nevertheless, my lord, fairness in the opportunity should be there.
That is what. See, you have to determine. You see, we have to establish one thing, that by, you see, like forcing you to appear for the trade test on the same day.
day.
you have been deprived of a chance to perform better.
My lord.
Now you have to substantiate by saying this. It's a mere statement will not do. You have to show us that how a quality which a person should have had in him should have carried with him get hampered if it has to perform in the meeting.
My lord.
Likewise, a singer, you just tell him to sing here. Of course, by giving all those supporting hands and all those things. I think he will be performing it. What is there?
At the moment, 5% plus minus maybe his performance.
That
will
is
be.
what.
Or a driver,
there
my
may
lord,
be an excuse of
for that matter, my lord.
rehearsal and no rehearsal.
For that matter, a driver, my lord.
Yes.
For a matter, it was a post of driver, my lord. Driver will not require 15 days time to come prepared for driving. My lord. He should be able to drive there and there.
My lord, in my respectful submission, my lord, this ground which my senior friend is taking, my lord, these grounds were never taken earlier, my lord. Pursuant to the observation from this honorable court, my lord, now they have started taking.
Definitely, because this was probably. Have you? This is it that your case is based on that this allotment of time?
My lord, allotment of time.
Is the main contention in your?
No, this is not the main condition.
My lord, another is, my lord, the biased.
Was there that stand was taken in the writ petition?
Biased.
You have taken that stand in the writ petition, Mr.
My lord, in the writ petition, I have taken the stand of biasness. My lord.
Biasness. This is not a
What about the allotment?
That he was not given sufficient time.
Is there any specific averment by you? At least you should give them an opportunity to reply also. You cannot just suddenly take them by surprise, raising some points.
No, my lord, the fact, my lord, the record will clearly reveal that, my lord.
That is all right, but then you have to make out your own stand. Record will reveal. But then, if it is a stand by you that because of the holding of the trade test on the same day, you have been deprived of the opportunity of performing well, then there has to be an averment to that effect.
My lord, that averment is not there in the rejoinder, my lord.
Rejoinder is no basis, you see. Rejoinder is for
My
the
lord,
purpose of
rejoinder was
clarifying.
on the basis of the, my lord, affidavit in opposition which
My
is
lord,
filed
the
by.
petition, the entire case is, my lord, that because he came to this honorable court for domicile certificate, and that is why he was victim.
My lord, that's why I said there.
That is the only stand.
My lord, definitely two grounds are there, my lord. One of them, on the other occasion, also, my lord, I had stated that also the biasness that I have.
If you take a stand in your rejoinder, how do they reply it?
But my lord, this is what the record clearly reveals.
See, the filing of rejoinder also is not a regular thing in a writ petition. It comes only in a situation where clarification is needed. Okay, and that is why for filing rejoinder, you have to take permission from the court.
But
otherwise, it has to be a writ petition and the counter.
But there an instance.
And your case, your major contention has to be a part of the writ petition, not a rejoinder.
My lord, the difficulty here is, my lord, because I have entered the case at a much later stage, my lord.
Do not say about
my lord,
you being counsel. You being counsel has no bearing in the merit of the case.
No, my lord, only.
You see, it is any deficiency in petition should not be taken as your deficiency in your personal performance.
No, my lord.
Should not be considered that way. So do not make any submission from that angle.
No, my lord. My difficulty is there, my lord. If in case, my lord, that averment is not there, my lord. Now at this juncture, it will be difficult for me to change it, my lord.
That is all right. That is why it will have a bearing in the outcome of the decision.
However, my lord, in the rejoinder, I have definitely taken that ground, my lord. Now, that also, my lord, after going through the records, my lord, then I made this submission, my lord. The record will clearly reveal, my lord. The record clearly reveals, my lord. Now, whether that can be ignored, my lord.
But then again, you see, one thing, this court is not very much convinced to stand, Mr. Bhattacharya, that you could not perform well because the trade test was conducted on the same day. Until unless you can show something.
But my lord,
this court will not agree.
But my lord,
until unless there is a justification to show it, you just show us that when an examinee is required to do some practical performance, he must be given some opportunity before that. Do you have any such law?
My lord, I have looked for some judgments, my lord, but to the point I am not getting. But two judgments have come across, my lord, where because the second chance was given to the candidate, my lord, to perform.
No, that
because
is all
here
right.
also my prayer is that give me another chance.
You have to place the definite set of law.
My lord.
Just because, you see, like you take a stand that you have been discriminated, others are given more time and you are given less time. There is one explanation to it, as has been raised by learned senior counsel here.
But my lord,
see, there the thing is that he has already said that is for administrative convenience. It is impossible when there is a number of candidates to hold it on one day, and that argument seems to be quite acceptable.
My
Okay.
lord,
Now to counter it, probably you have to come with some law.
so my lord, if that is so, my lord, my respectful submission, my lord, in matters of public employment, my lord, fairness of opportunity should be equal for all, my lord. There cannot be a different yardstick for
Definitely.
me
See,
as
what you
well
say,
as for others.
you
my
say
lord.
fairness of opportunity.
My lord.
Now, what can be constituted as opportunity? That is the question.
For me, my lord, the call letter, my lord, when I received the call letter from the for the written test, my lord, if that is so, then they could have, if let's assume this argument, my lord. So if that is so, I was the only candidate. So my lord, they could have taken the physical test, the written test, and the trade test on the same day. Now, physical test they took on a different day. They issued a different call letter for my written test. Now, certainly on the call letter for the written test nowhere mentions, my lord,
But
that
in which way it hampers your performance?
my lord, because I was taken by surprise. I was not prepared.
Can it be?
My lord, the selection committee is a board of officers with supposed to be 3 officers, my lord. For one individual, you have to call 3 officers from different.
So my lord,
that is why your argument of administrative convenience comes.
So my lord, if
that is okay. So everything will fall under that argument of administrative convenience. Basically for the petitioner to show that he has been deprived of performing or giving his best. Now there has to be something in such a case to show. You see, had it been a case that he said that he was asked to perform the trade test without any supply of basic infrastructure, that you tell him to cook, we do not give him a proper kitchen. Okay, there is no proper system of lighting fire. Okay, he may have a justified thing, but then once his argument is not based on lack of supply, lack of infrastructural things, then to what extent that argument will stand? That is what the question is.
My lord,
Just because you see, like you cannot just say that I have been caught by surprise and that is why I could
no, my
not
lord,
perform.
if that is so, my lord, if they had all intentions to hold the trade test on the same day, my lord, when I received the call letter for the written test, my lord, there could have been a clear indication that in the event you qualify.
They have admitted that they have not given an indication.
Yes, my lord.
So there is no dispute to that part. Now, only thing is that by not giving that, which way it has hampered?
And
that is
my friend has already admitted to the fact that everything was structured, my lord. That so and so will be conducted on this. So first you have the physical, then you have the written, then you have the trade test.
No, that is we can understand.
My lord.
That the structure comes because of certain reason, and if it is for the purpose of administrative convenience, that is solely for them to consider. You cannot be a part of administrative convenience until and unless you can project before the court that because of their administrative convenience, your right has suffered. So you have to make out that case.
My lord. My right has definitely
Dr. Mojika, if you furnish us that how many candidates were there, then details, then we can have it hearing on next day. That is all right for you. And please furnish him also the details until and unless something is confidential. You see, I don't think there will be. So that he can also be prepared. He shouldn't be something like that. Then he said that again he is deprived of.
No, Lord, for that matter, I had.
Now, then he will say this court has given Dr. Mojika 2 weeks time and I have not even given 20 minutes. So then again it will be a problem.
No, for that matter, my lord, I had also filed RTI, which was rejected on 2 occasions, my lord. Then I had to file second appeal, the outcome of which, of course, I am not aware.
But we are
seeking all this information
CRPF
from the
is
department.
not subject to RTI generally, my lord. There is an exemption clause.
But in the earlier round, they have issued information.
I'm the different thing. This court is not on those things.
I'm placing all the material.
Or not. We are not deciding it. That you have to move as per the line prescribed by the law. When can you have it, Dr. Mojika?
10 days time. Lord.
Then it will go
after
to
2
weeks
weeks
again.
Well.
Yes, as requested by the landed DSJ. This matter after 2 weeks. With further 2 weeks time is granted. Now, another 2 weeks, you just say another 2 weeks time is granted for obtaining further instruction in the matter.
Item number 12.
List accordingly.
Obliged, my lord.
Please see that part, Mr. Vade. That point. Yes.
His Lordship. In this matter, Mrs. Thapa is leading in this matter, Your Lordship.
Yes.
His Lordship, his unbereavement, Your Lordship. So I'm.
Thapa is a bereavement.
Your Lordship, I'm.
When do you want it?
1 week, Your Lordship.
Okay. Mr. Shoinsu, appearing for the petitioner, prays for grant of some time. On the ground that Mr. Thapa, learned counsel, appearing for the petitioner, is on bereavement. List this matter. When? 1 week. After 1 week, you said.
2 weeks, Your Lordship.
Yes.
Lordship, let it be 1 week, Lordship. It is a prolonged matter, Lordship. Yeah, only on one issue, Lordship, here, 7I, Lordship, that appeal was it.
Okay, just say
It is-
the respondent has no objection. List after a week.
Obliged. Obliged.
Obliged.
No other.